Chapter 7. Despite strong privacy regulations, medical information is widely used. In general, health-related information can be covered by HIPAA or some other sector-specific law. The first medical legislation comes from the 70s. This relates to alcohol and drug abuse. The confidentiality requirements from these laws were implemented in the Confidentiality of Substance Use Disorder Patient Registration Rule. Written patient consent must be obtained before any patient-identifying information can be shared. The consent form may contain a general consent statement, stating that disclosure may be made to other parties, such as those who have a treating provider relationship. To increase the efficiency of electronic healthcare payments, the Health Insurance Portability and Accountability Act was adopted. HIPAA defines protected health information. Covered entities to which HIPAA applies are healthcare providers like hospitals that conduct certain transactions in electronic form, insurers, and healthcare clearinghouses. It is important to understand that HIPAA applies to these covered entities, but not to other healthcare providers and services. HIPAA contains a privacy and a security rule. The privacy rule provides a detailed implementation of the Fair Information Privacy Practices. For example, to increase efficiency, HIPAA authorizes the use and disclosure of PHI for treatment, payment, and operations. Opt-in is generally required for other uses or disclosures of PHI. The security rule establishes minimum security requirements for PHI that a covered entity receives, creates, maintains, or transmits in electronic form. Reasonable security measures are required. Some requirements are: designate a responsible person for a security program, and conduct initial and ongoing risk assessment. HIPAA does not preempt state laws that provide more protection than HIPAA. It is particularly important to check state law for additional rights for patients and the use and sharing of information. The HITECH reform provided incentives for healthcare providers to adopt electronic health records and develop a national electronic health information exchange. A breach is presumed in the event of unauthorized acquisition, access, use, or disclosure of information. There is no breach if the covered entity demonstrates that there is a low probability that the PHI has been compromised. In case of high probability, the individual must be informed within 60 days of discovery. If more than 500 individuals are affected, the covered entity must notify the U.S. Department of Health and Human Services immediately. All breaches requiring notice must be annually reported to the Office for Civil Rights. HITECH made changes to legal treatment of electronic health records under HIPAA. Covered entities must provide individuals with a copy of their records on request, must account for all non-oral disclosures, may not sell records without consent, and cannot use records for all marketing purposes. Two other laws in the field of medical privacy are GINA and the Cures Act. GINA limits the use of genetic information in the field of health insurance and employment. GINA prohibits health insurance companies from discriminating on the basis of genetic traits. It prohibits employers from using genetic information when making work decisions. The Cures Act has numerous privacy-related provisions to protect PHI when used by pharmaceutical companies and other involved parties.